What's up, y'all? It's your girl Tree with another tip here from Tree Tips Media. I am stationed right now, as y'all can see, in my kitty lounge, and it is so beautiful. I just feel so relaxed up in here, so I had to come to you guys and give you this content. Oh, yeah. So, guess what, guys? What? We got a new judge in YSL trial, right? I don't even know if she's going to be able to stick around. There's a lot going on with her. And I don't think, I'm pretty sure some of the information is out there. But I just wanted to know who she was and to see if she was going to be able to stick around. Because, yeah, I think they're running out of judges for this trial. Just saying, just saying. But anyway, so let's pull up her picture. Her name is Judge Paige Whittaker, and she's beautiful, beautiful lady, beautiful young lady. She doesn't look like she's that old. Um, yeah, has a beautiful smile. Now, I know what you're wondering. What Tree? Well, what is the show about? What is the tea on her? Well, let me give y'all the tea on her. The tea is, remember how Judge Glanville had us in this zone where he was just on the prosecution side? Well, this beautiful judge, young lady right here, has ties to the defense. Yeah. The one and only Brian Steele, she has ties to, and two other attorneys on the defense as well. But word is, y'all, and let me give y'all this tea. It's a little tip from Tree. She had a party. I don't know if it was her election party or pre-election party or whatever, but Brian Steele was in attendance, getting his party on with her, honey. Yes, he was in attendance. So, and other defense attorneys. And I got to wondering, like, I know they all party and shit, probably go to lunch together, but at her election, a defense attorney? Yeah, got me to wondering, like, what is going on with this? Is this more to meet the eye? I don't know. It just don't seem right for a defense attorney to be at a judge election. Why would he? Why would he? So I got to dig in a little bit. And Judge Whittaker, she not only has some love with the defense attorneys, but she got a little beef with the prosecution team, honey. Yes. Okay, so let me take y'all back. So the governor of, well, let's just get into this. You know what? Let's just get into this. So while I'm pulling this up, the governor of Georgia, when I don't know if I believe it's when they started going after Trump. Fulton County started going after Trump. The governor of Georgia threw a bill out there for Congress and they signed it. And the bill was to have a special commission team to investigate district attorneys when they have done things wrong. Not only when they've done things wrong, but just investigate all of their cases would be open to this commission, right? And the commission will go through it like a fine tooth comb, make sure all of their I's are dotted, T's are crossed, right? Also, if the commission finds out that they've done something wrong, the commission will then submit it to Supreme Court of Georgia and have those judges to look over it. If those judges say, well, I don't think they've done anything wrong and deny it, then nothing's done behind it. But if those judges accept it and say, yeah, this district attorney has done something wrong, then the commission board will have an option whether they want to keep the district attorney and just discipline them, or get rid of them. And Congress signed a law. It's called SB 92. And yeah, and Governor Kemp signed off on it, of course. So yeah, district attorney, they filed a motion And when they filed a motion against this law, I guess to have it thrown out or whatever, their motion went to your very own YSL New Judge Whitaker. Yes. Whew, a lot goes on in Fulton County. Georgia. Georgia. Okay, so this is, and I actually found the motion. Someone sent it to me. So I want to get into it. It's only like 6 pages, and I want to read it to you guys because I think it's very, very interesting. I am not a lawyer in the least. I didn't take any law classes, but I do have my master's degree in business administration. So I can understand, not too many legal terms, but certain things, right? Because I took healthcare law, but certain things I can read and understand. And certain things I don't know what it's talking about, right? I'm very bad at pronouncing words. So this is going to be like my first time reading the document live. And I think it's one word on there that I have a hard time with, maybe a couple, but you'll see. Anyway, I'm going to post the document as well so you guys can look it up as well and read it for yourself. So let's get into it, guys. Wow. All of these judges recuse themselves because they're tied to this case in some kind of way. And lo and behold, this judge is not tied to the case, but she's tied to people in the case, on the defense and the prosecution, basically. So, child, this is some tea. No, this is real tea. Tea and a splash of lemonade and ice. No liquor. I just got liquor in the background for the decorations. Got me some Shea La Porte. Thanks, Shannon Sharp. Appreciate it. All right, so let's get into this. Let's go. Let's go. So this is an order actually denying their motion, denying the prosecution motion. So let's get into this, y'all. So keep in mind, the prosecution is the plaintiffs in this, the prosecutions that brought the motion to the courts, right? And the defendants is basically the commission people. It's a civil action file. They have a case number and everything. It says order denying plaintiff's motion for interlocutory injunction. And interlocutory, that's not that word, but it's interlocutory. Interlocutory. I got it. All right, interlocutory injunction. Okay. Order denying plaintiff's motion for interlocutory injunction. Before this court is plaintiff's motion. Now, this is Judge Whittaker's response to denying their motion. So before this court is plaintiff's motion for interlocutory injunction filed on August 24th, 2023. The motion asks this court to join the defendants and commissioners of the newly created prosecuting attorneys Qualifications Commission from conducting an investigation or disciplinary proceedings during the pendency of this litigation. Defendants filed an opposition to the motion on September 18th, 2023. A hearing was heard a couple of days later on the motion on September 22nd, 2023. After consideration of the pleadings, the briefs, and the arguments at the hearing, plaintiff's motion is, in big black letters, y'all, denied, it says. Listen, she didn't hear what they had to say, and they had put in that motion to stop this commission from conducting an investigation or disciplinary proceedings while this litigation alone, while this motion was filed. But She denied it within a couple of days. She didn't even let it go on a week. She did. Okay. So let's get to it. So the litigation at issue, the Georgia Constitution provides for the existence of the district attorneys, and that same Constitution specifically gives the Georgia legislature the authority both to delineate the duties of the district attorney and to discipline or remove district attorneys. In keeping with that authority, the General Assembly recently passed Senate Bill 92, SB 92. You're going to hear that throughout this motion of denial, which was then signed into law by Governor Kemp. SB 92 amended, which governs the duties of the district attorneys within their respective circuits, to enumerate a new statutory duty. To review every individual case for which probable cause for prosecution exists, and make a prosecutorial decision available under the law based on the facts and circumstances of each individual case under oath of duty as provided in code. And she gives the codes. SB 92 also added a new code section, which establishes the Prosecuting Attorneys Qualification Commission as a body which may investigate and discipline or remove district attorneys and solicitor generals. Cover both of them, right? All right. The authority of the commission shall be limited to incapacity or discipline regarding the conduct of a district attorney or solicitor general as a holder of such office. All right. So she put a little, when I tell y'all, a little portion of the plaintiff's request for injunction in here. I mean, she put a total of 3 sentences. So let's get into it. Plaintiffs' request for injunction. Plaintiffs assert that the legislature has overstepped its authorities in violation of Georgia's separation of powers doctrine, that the commission violates both the state and federal First Amendment and due process rights of plaintiffs, which is prosecutors in this case, and that a preliminary injunction barring defendants from conducting any investigatory or disciplinary proceedings is warranted during the pendency of this litigation to prevent imminent and actual harm to plaintiffs, actual harm to prosecutors. So what they basically stated, and she only put, and I'm pretty sure they had way more than this little portion that she put in there, but what they basically stated their issue was with SB 92 is that it violates the prosecutors, both state and federal First Amendment and due process rights. How it does that, I don't know. But let's read the little imprint in between before we go on to the next paragraph. It shall be the duty of the district attorney to represent the state in all criminal cases in the trial and appellate courts of their respective jurisdiction, and to perform such other duties as shall be required by law. Any district attorney may be disciplined, removed, or involuntarily retired as provided by a general law. And then she put a case up there. SB 92 requires the commission to adopt rules and regulations that comport with due process no later than October 1st, 2023. And those rules shall be effective only upon review and adoption by the Supreme Court of Georgia. SB 92 also provides that no complaint may be filed with the commission against a prosecutor prior to October 1st, 2023, or about misconduct occurring before May 1st, 2023. So if conduct occurred after May 1st, 2023, they can file on that conduct, I think, or about misconduct. Oh, no, they can't. They can't file on anything about misconduct or misconduct before prior to October 1st, 2023. The commission has thus far not published any proposed rules and has agreed that no prosecutor will be subject to discipline until the Supreme Court of Georgia reviews and adopts the proposed rule. So what they're saying basically is, and this is important to her ruling to denying them, you guys don't have to worry if you are doing your job. If the prosecutors are doing your job and everything is in line, you don't have to worry about any disciplinary action, because even if the commission find that you're not doing your job, it's going to go to a second set of eyes, which is the Supreme Court of Georgia, and they have to look at it. Now, if the Supreme Court of Georgia say that you have done something wrong, then you will be disciplined or removed or involuntarily having to retire. But if the Supreme Court of Georgia look at their report and say, hey, that's mild, that's nothing harmful, then you have nothing to worry about. So basically do your job and do it correctly. She went on, okay, so basis for denial of injunctive relief. The court reaches its decision to deny the motion of several independent and alternative reasons. So she gave a couple of reasons why she denied this motion, which is why I really love this judge. She's thorough and she got it outlined so well. It's really, yeah. First reason why she denied: standing rightness. At this point, plaintiffs, which is the prosecutors, have failed to show a cognizable injury for purpose of standing. And then she gives a case. Rather, their alleged injuries appear to be inconjectural or hypothetical and not based on a present set of facts. So with that being said, what she's saying is you guys just gave me hypotheticals. Nothing has happened to you right now. So there's nothing that I have to base what you're saying on as a fact that's going to even happen to you. And prosecutors, plaintiffs basically, self-censoring attested to in their affidavits is based on questions that have not yet arisen, but which plaintiffs, which is the prosecutors, fear may arise at a future date. Then she gave a case law. In addition, because plaintiffs allegedly injuries are based on an unspecified future harm, which will be caused, if at all, by the defendants, future discretionary acts, any injury is neither actual nor imminent, and standing requires. And she gives another case law. So she's basically saying that you don't give me any hypotheticals about what the defendants might harm you doing until we need to know it when it happens, if it happens. You can't say this person is going to harm me, and I guess in a motion like this, they want to see the harm, or if harm is even going to be done. Nothing might not happen. So let's go on. I love this motion because she's right about this. She's definitely right. Sovereign immunity. In addition, plaintiffs' federal law claims as pled are barred by sovereign immunity. To overcome sovereign immunity, plaintiffs must identify where the state has waived the defense, and she gives up case law. Plaintiffs attempt to do so in footnote 1 on one of their motions. And with the quotation marks, plaintiff bring this lawsuit and seek this injunction against defendants in their official capacity and on the federal law claims pursuant to Ex parte Young, and in their individual capacity and on the state law claims. And she gives case law. This cannot overcome the state's assertion of sovereign immunity on the federal claims. The federal claims are pled pursuant, and as she gives the code, does not permit claims against state officials acting in their official capacity. So she's basically saying the feds cannot come after you for acting in your official capacity if you're not doing anything wrong, right? And she gives case law behind it. And plaintiffs' reliance on Ex parte Young does not cure this error, as Ex parte Young does not defeat sovereign immunity in all contexts. It is a means of establishing federal jurisdiction and federal courts. In those courts, it has been recognized as an exception to 11th Amendment immunity. Then she gives case law. Ex parte Young was the culmination of experts by the court to harmonize the principles of the 11th Amendment with the effective supremacy of rights and powers secured elsewhere in the Constitution. Sovereign immunity, however, never derives from nor is limited to by the terms of the 11th Amendment. That I have to look more into this Ex parte Young to see exactly what the prosecutors, which is the plaintiffs in this denial motion, that was their argument. That was the case that they brought up. So I'll look that up at another time and probably do an extension onto this video. Let's go to the next reason why. This is interesting, right? This is really interesting. She laid it out why she's denying this. Standard for injunctive release. An interlocutor, that's that word again. An interlocutory, I think that's it. Injunction is an extraordinary remedy, and the power to grant it must be prudently and cautiously exercised. And she gives case laws for that. Injunctive relief should be granted only in clear and urgent cases after considering, number one, whether there is a substantial threat of irreparable injury. Number two, whether the threatened injury outweighs the harm caused to the injured party. Number three, whether there is substantial likelihood of success on the merits. And number four, whether an injunction would work a disservice to the public interest. Plaintiffs have not satisfied the requisites to obtaining an injunction. Oh, yeah, she laid it out why she denied their biggest thing with her. Okay, so let's go. This is still under standard of injunction release. So, number one, as the Georgia Supreme Court has instructed, injunctions should be only granted if the injury is pressing and the delay dangerous, and not to allay mere apprehensions of injury. Allay mere apprehensions of injury. She gave case law. Plaintiffs have not articulated any injury linked to the commission's investigation of prosecutors. And the commission has indicated it will not discipline a prosecutor until the Supreme Court of Georgia approves its proposed rules sometime into the future. Further, defendants enjoy a presumption that they will follow the law in the exercise of their statutory duties and authority, and she gives case law. Internal quotations omitted, and that the commission will execute its duties in good faith and consistent with the constitutions of the United States of Georgia, meaning we're not going to just come at you if you haven't done anything, Mr. DA or Mrs. DA. We're going to look at this very ethically. We're going to investigate and we're going to be very fair with good judgment, right? The presumption prevents the courts from accepting the plaintiff's concerns as factual at this stage of the litigation. Plaintiffs have not shown an injunction is the vital necessity to preventing an immediate and irreparable injury. And then she gives case law. While the threatened injury to plaintiffs, number two, while the threatened injury to plaintiffs is at this point speculative, it is also true that the commission is newly formed, but anytime a state is enjoined by a court from effectuating statutes enacted by representatives of its people, enacted by representatives of its people, meaning the people voted for this, it suffers a form of irreparable injury, meaning the people of Georgia voted for this. They wanted the district attorneys and prosecutors to be held liable if they are doing misconduct on them, on their people. And if this judge is saying, and if I take that power out of the people of Georgia's hands, what's going to happen when we need them to come for jury duty and be fair? What's going to happen then? So that makes a lot of sense. And she gave case law. As the burden is movements, and since duly enacted statutes enjoy a presumption of constitutionality, and she gave case law, the balance of the equities weighs against enjoining defendants from acting. Once all statutory prerequisites to such action have been satisfied. Number three, plaintiffs have not demonstrated a substantial likelihood of success on the merits. And while the court has weighed all of the factors in determining whether to grant injunctive relief, meaning I've looked at all the factors, unlikelihood of success on the merits standing alone warrants the denial of injunctive relief. So she's letting them know the unlikelihood of success on the merits that you gave me, and you only gave me that standing alone. That's what's warranting the denial of this of the injunctive release. And she gave case law. Among other things, the court is persuaded that the Georgia Constitution expressly authorizes the General Assembly to impose duties on the district attorneys and create grounds and processes to disciple and remove district attorneys who fail to meet those legal duties. So in addition to us investigating SB 92, investigating you, SB 92 also wants you to go by these new set of ground rules and legal duties, and that SB 92 does so within the bounds of the state and federal constitution. Lastly, number four, the public interest is served by allowing the defendants to perform their duties as SB 92, as duly enacted by the legislature and enjoying a presumption of constitutionality, represents the will of the people, meaning the people voted for this, the people wanted this, and the people got it. And I'm not going to be the judge that take it up out of the people's hands, and I'm not going to allow you guys to take it up out of the people's hands, because all you have to do is your job correctly. You have nothing else. And so ordered this 29th day of September, last year in September, the Honorable Paige Reese Whittaker, Superior Court of Fulton County. There you have it, guys. The new judge on a YSL case denied a huge motion of injunctive relief for the prosecutors against a state law that was enacted and signed off by the governor. So I could just say the prosecutors don't like her too well. I'm gonna just go out there. I'm gonna dive out there and say it, and I'm gonna also swim back laughing and say the defense loves her because Brian Steele was at her party, partying it up, turning up with her. So, guys, yes, this trial, she hasn't recused herself yet. So, this trial, I can't wait. It's gonna be good. I wonder if the ties is gonna turn. I wonder how it's gonna be. Interesting. Anytime we have a chance of putting our foot on the prosecution neck for doing crazy and unethical stuff, I'm here for it. And it's been done in this case, and everyone is tired of it. So if you haven't already, subscribe. Look at my banner at the bottom. I got my YouTube subscription, my YouTube name, Tree Tips 2021. Follow me on there. Follow me on IG, Tree Tips 4. Follow me on TikTok, Tree Tips 04. We go live on all of those. Haven't figured IG out yet, but I'm going to figure it out, right? I need you guys to follow, like, and share this content. Get me in the algorithm, trying to build up that content. You already know, trying to get monetized just like everybody else. So Tree Tips Media, keep tuning in. I'm going to keep pushing that content, keep giving you updates, keep researching, and keep putting it out there. And until next time, tune in to Hootie Who's Finest Talk Show every Wednesday, 5 p.m. Pacific Standard Time, 7 p.m. Central Standard Time, and 8 p.m. Eastern Standard Time. Till next time, guys, your girl Tree is out of here. Some moochies.